Yeah, very. Yes.
May it please, Your Lordship. My Lord, with respect to item 1 of part 2,
Yes.
we had one.
Supreme Court.
Yes, Your Lordship.
That
So
is
the latest
pending.
order we provided,
Okay.
just to update Your Lordship on
What is the status now?
the status, it's been fixed for a hearing now,
Okay. We'll have some, we'll adjourn this matter for some time.
my Lord.
All the councils are there?
Yes, Your
Yes.
Lordship.
Okay. The learned counsel for the parties have informed that the concerned SLP was last listed on 20/11/2024 when the Honorable Supreme Court had directed the matter to be listed for hearing. Full stop. The interim order was also extended till the disposal of the said appeal. Full stop. Para. In view of the aforesaid development, the matter is adjourned for a period of 2 months. Full stop. If there is any development in the meantime, the learned council would be at liberty to mention the matter.
Deeply obliged.
Your Lordship, if I may be allowed to mention item 3 from part 2.
Part 2, yes?
Your Lordship, the state respondents have submitted an additional affidavit regarding the status of the investigation made by the SIT. And if I may state, Your Lordship, that as per the report which has been submitted to the Honorable Court, it is dated March of 2024.
Okay.
And we are in December 2024. And as per the status report, there were about 5 witnesses to be statements to be recorded. So if they may be directed to give a status report as on date, since
Yes.
8 months have
State
passed.
council?
If your lordship will allow us a week's time, my lord.
This will remain in the list? This is a part 2, isn't it?
Yes.
It will
Yes,
remain
Your
in the
Lordship.
list. You come up with your instructions.
Yes,
What
Your
has
Lordship.
presently happened? Will this matter will not be called upon this week? Next week, next
Coming-
Monday, next Monday.
Then, Your Lordship, maybe a date may be kindly fixed. This is for only this week.
This list is for this week?
Yes.
Okay. The learned counsel for the petitioner has submitted that pursuant to an earlier order of this court, status report of the ongoing investigation was presented, which, however, is of March 2024. Full stop. Para, to enable the state respondent to obtain the up-to-date status, matter is adjourned to be listed on,
9th.
we'll have it on 11th,
I will-
on 10th. One more day, 10th.
Obliged, my
Your Lordship, 10th I have some problem. Anyway,
11th?
yeah.
11th is okay for you?
Your Lordship, I'll be out of station.
Okay, 9th. 9th is
9th.
9th.
Ninth one.
I'm on that. And Your Lordship, there's item 5.
Yes.
This may kindly be taken up on Thursday.
Okay. 5 Thursday.
Thursday.
It will remain in the list.
Yes, I'm obliged.
My lord, if I may be kindly allowed to mention item 6 of the part 2. My lord, the learned PP taking up the matter is been hospitalized with a new baby. So she's most probably not coming this calendar year.
Okay.
So if the matter may be fixed after vacation.
Okay. It has been submitted that the learned PP is on medical leave. Medical leave?
With a new baby. With a new baby.
It is on medical leave. Full stop, para. In view of the above, matter is adjourned to be listed in the month of January 2025.
Obligation.
My lord, item 12, part 2, item number 12.
Yes?
With the consent of the other party, my lord, the matter may be taken up after vacation, my lord.
25, item number 12 is matter of which year? 22. Why are we seeking time? Why are you seeking time?
My lord, that is as per the proposal of the other party, my lord.
That will not do. If you have some difficulty, tell us. We'll adjourn, but not just 22 matter. Doesn't look good. We're at the end of 2024. Let it remain. If you have some difficulty, tell us. We'll accommodate, but not like this. Yes, next.
Your Lordship, item number 10. I have been informed that
10 of the part 2.
Part 2, yes.
Yes.
I've been informed that the appellant
10,
is
10, 10 is connected with 9.
yes, every
9, 8, 7,
Yes.
all matters are connected.
yes. Particularly with regard to 10,
Yes.
the appellant is intending to engage a counsel, senior counsel. So I have been requested to make a mention.
Have you
that he
taken the
may give
consent
them
of the other
time.
councils?
Yes,
7, 8, 9, they have been informed.
all of them are there.
What about the 7 and
7 also.
Seven, my lord, he's died.
But it's represented by wife.
Substituted by the wife.
Substituted, yes.
Yes.
okay, substituted?
7, 8, 9, and 10 is all are connected matters.
Okay. When do you propose to engage a senior?
Yeah, but after vacation it will be finalized.
Item number 10. Huh? What is your name?
Roshan Subedi.
Sri so-and-so learned counsel has submitted that the client has instructed him to engage a senior counsel, and accordingly he pays for some accommodation. Fair? Since the other matters are connected, comma, the same are adjourned to be listed in the third week of January 2025. Okay.
Obliged.
May I please, Your Lordship, I would like to make mention of item number 14, part 2.
14, yeah. Criminal appeal.
Yes, my Lord.
You're an amicus.
My Lord, the amicus is my senior, but he has applied for leave until the 13th of this month as he's getting married this week. So if this matter may be taken up after the vacation.
You have a very good cause.
Yes, ma'am.
Good cause. A bad cause.
It's a good
cause.
supposed to be a good cause.
Supposed to be, yes. Okay. It is submitted on behalf of the. A prayer for adjournment has been made on behalf of the learned amicus on personal grounds. Yes, other side informed. PP, there is a respond number 2.
I have no objection. Respondent number 2, Miss Emily. I don't know whether
It's
she
a
has
POCSO
been-
matter.
Yes, my Lord.
Where is the R2? Have you informed or not?
My Lord, I could not.
No, you should inform. Don't make a mention. That should be the practice. You inform, we'll accommodate. You inform, we'll pass orders. Inform and come back to the court. Okay?
Yes, ma'am.
14 में तो नहीं होगा, लेकिन लिख दीजिए.
Daily list for motion, item number 1.
May I please, Your Lordship?
Yes.
Yes, this is civil revision petition filed under section 105 of CPC directed against the impugned order dated 37/2024 passed by the learned Civil Judge Junior Division 4, Aizawl District in CMA number 435 of 2023 in connection with civil suit number 38 of 2019, whereby the instant petitioner was made to substitute his deceased father, who was arraigned as defendant number 5 in the main civil suit. And the said application for substitution was.
What is your good name?
My name is Roland, K. Roland.
Mr. Roland, you tell us two things. You have
Yes.
taken up 2 points.
Yes, my lord.
Limitation.
Limitation.
And the number 1, that notice was not served upon you.
That's right.
Limitation, we have gone through the petition. He has not stated anything about knowledge part.
That's right.
And
And-
what is the prescribed period of limitation? 90 days?
90 days.
It's passed beyond 90 days.
Your 90 days.
Number 1. Number 2,
The second one is the suit was filed. I'm sorry. The misapplication. The main suit was being valued above 5 lakhs.
that is the point on merits.
Yes, my lord.
That is the point on merits. We are on the point of substitution.
Okay. Yes, my lord.
Substitution, you say, second point, you have said that
Second
notice,
point is-
notice was not served upon you. It was rather sent to the respondent number 5, original respondent number 5, your father.
That's right. And the second point is, as per Mizoram Civil Courts Act, Amendment 2021, pecuniary jurisdiction above 5 lakhs is senior civil judge.
Mr. Roland, this part of pecuniary jurisdiction is a curable defect. It can be cured. But your substantial point is that the substitution has not been made by following the due process of law.
That's right.
That is your primary point.
Primary,
Okay. We'll issue notice.
Yes, my lord.
You're praying for a stay or what?
Yes, my lord. At the time of filing the instant petition,
Okay.
it was
Sri K. Roland, learned counsel for the petitioner, who by means of this petition filed under section 115, read with section 151 of the CPC, has assailed an order dated 30/7/2024, passed in CMA 435 of 2023, arising out of main case. Huh? Please have your seat. Arising out of so-and-so. It is the case of the petitioner that the original defendant number 5 was his father, who had passed away on 18/3/2023. Whereafter, the present CMA was filed on 26/2023. It is submitted by the learned counsel that the said application was filed beyond the prescribed period of limitation, which is 90 days. He has also submitted that summons were never issued to his client, and rather the office note and orders of the learned judge was in connection with notices issued to the original defendant number 5. The learned counsel has also raised the issue of pecuniary jurisdiction. Para, let notice be issued, returnable on this second, returnable on 15th of January 2020, 15th of January, 15th of January 2025. Let, who are the parties?
My lord, I am representing for the state respondent number 1, 2, 3, number 2, 3, 4, and 5.
2, 3, 4, and 5. Ms. So-and-so, please write her name. Learned State Council accepts notice on behalf of respondent numbers 2, 3, 4, and 5. Let extra copies of the petition be served upon her. Let steps be taken for service of notice upon the respondent number 1 by registered post with AD. Steps within 2 days. Para. The learned counsel for the petitioner has prayed for an interim order. Para. Considering the above facts and circumstances, and also after perusal of the application filed, application which was registered as CMA 435/2023, which has been annexed to the petition, wherein there is no statement with regard to the aspect of limitation, the further proceedings in civil suit number 38 of 2019, pending before the so-and-so, shall remain suspended. Para. Since this order has been passed ex parte, the respondents would be at liberty to come up for modification, vacation, alteration, if so advised.
Mr. Black.
DB days, okay. Mr. Counsel will have another date. Some Wednesday may be some difficulty, or court master will have the returnable date when? 14th or 16th? 16th.
16.
Item number 2.
May it please your lordships. My lords, this case pertains to, my lords, the petitioner's land, which is adjoining the national highway in Serchhip district.
You are asking for damage.
Yes, my lords. My lords, the government has themselves made an estimate of the amount of damages. Even the...
Has the damage been quantified?
Yes, my lords.
Quantified?
Yes, my lords.
There is no disputed questions of fact here.
No, my lords.
Okay. Your name?
My lords, Jordan Advocate General.
Okay. Poetry, so, number, a learned counsel for the petitioner who by means of this petition has prayed for damage compensation pertaining to the land. First up, the learned counsel has relied upon a report dated 9/8/2023 prepared in this regard. Para, let notice be issued, returnable by 6 weeks. Ms. So-and-so, Learned State Council, accepts notice on behalf of respondent 1, 2, 3, 4, 5, and 10.
10, my lords.
10. And Union of India, who's there? Union, and what about NHI? Respondent number 6, madam. And,
Yes, my lord,
7,
I'm
2.
representing for the state government.
Okay, we've given 7, 8, and 9. Court must please give the names, okay? Extra copies be served upon the learned counsel for the respondents by tomorrow.
Grateful, my lords.
Item number 3.
Please, Your Lordship.
You say that it's covered by the earlier judgment?
Yes, covered matter.
Okay, madam, you take instructions. We'll try to have this next week, try have the instructions.
Yes, my lord.
Okay. Heard, Ms. So-and-so learned counsel for the petitioners who is aggrieved by deduction of 10% cess
Right.
from the land compensation. First up, the learned counsel submits that the issue has been decided recently by this court, vide a judgment dated 21/11/2024, and accordingly relies upon the same. Para, on the prayer of Ms. So-and-so Learned State Council, matter is adjourned to be listed on, we'll have it on 9th, is it okay?
Yes, sir.
9th, to enable her to obtain the instructions as to whether the matter would be covered by the earlier judgment.
Obliged.
To facilitate her to take the instructions, learned counsel for the petitioner would furnish extra copies of the writ petition during the course of the day.
For admission, item number 4.
Yes.
If I may, my lord, we have approached this honorable court for, as we are grieved by the judgment and order dated 23/8/2024, specifically that para 21, wherein
Para 21 at page 57, please read.
yes, ma'am. With regard to making seizure of the Arakanat, the learned counsel for the accused person had honestly, during oral argument, submitted that the Arakanat had been keeping inside the building at DC Complex Mamit for a long time and decayed. Hence, they make no claim on it. Hence, all the seized Arakanat shall be destroyed.
Your statement was there.
My lord, this is not the statement given by the learned counsel. My lord,
Okay,
at that time.
it may not be the statement. Look, where is your pleadings? How have you verified your pleadings?
My
Come
lord.
to your pleadings. And come to your verification.
My lord.
Come to para 21. Oh, para 21 has said, come to your pleadings. Where are the pleadings? That a wrong interpretation was given.
My lord, our main grounds is that the learned trial court ought not to have passed for destruction of the seized Arakanats upon acquittal of the accused, my lord.
I've understood.
My lord.
But the seizure was done in February 2023.
My lord.
The submission was made when? On 23/8/2024. Assuming that the submission was not made or it was wrong interpretation. Where is your pleadings? It cannot be orally be made. This is a very serious kind of a submission you are making. Wrong interpretation by the court. There may be. Wrong can be done by anybody, but you have to state. Where have you stated?
In page 31, my lord, of the petition.
Yes, 31.
Page
Number
31.
3. Please
Number
read.
3.
Number 3.
Quoted, the learned court has wrongly interpreted the submission
Yes,
made.
how have you verified? How have you verified this pleadings? Have you verified these pleadings at all?
I have, my lord. There's
Where,
no,
where,
there's
where
no
is
such.
the verification? Come to the affidavit. You have not even verified this. Come to paragraph 3. Matters stated in paragraph 2 and 10 are true to the matters of record. Rest are submission.
Madam.
You give an affidavit from the council that he did not make such submission, or at least verify this. You have not even verified. And practically just see, February 2023, the seizure was made, Araknath.
Yes.
We are in the end of 2024.
Madam.
Your counsel has said, and read the language of the learned judge, honestly submitted its decade. Otherwise, there is not a big issue. When you are acquitted, this matter can be examined, whether to give back or not. But see how we presented this petition. You file an additional affidavit here. File an additional affidavit, make the pleadings properly, verify those pleadings, and try to have a affidavit from the learned counsel also that he has made such a submission.
My lord, I will do that, madam. Kindly grant me 2 weeks' time, madam.
Okay.
If lordship permits.
Your name?
Laro Kuma Pautu.
Okay. For this also learned counsel for the petitioner. Full stop. The present claim is for the is against the observation made in the judgment dated 23/8/2024 by the learned so-and-so, whereby there for destroying the seized Araknath. Full stop. It is the submission of the learned counsel that while making such observation, a wrong interpretation was made regarding the submission made before the learned court. Full stop. Para. This court has, however, noticed that there is no proper pleadings in that regard, and even the grounds taken in paragraph 12 within bracket small 3 has not been verified in the accompanying affidavit. Full stop. Para. At this stage, the learned counsel prays for some time to file an additional affidavit. Para. In the interest of justice, 2 weeks' time is granted to enable the petitioner to file an additional affidavit.
Deeply aware.
Ms. So-and-so, learned counsel, no state counsel event.
Orders, item number 5.
What can you increase the receipt?
Your Lordship, I'm standing on behalf of my senior, Mr. Johnny L. Thompson.
Item number
5.
5. Okay. What is it? Yes.
So I'm standing on behalf of my senior, Mr.
Doesn't matter.
Johnny L.
Yes.
Thompson.
Yes.
Yeah. So as per the court record book, the respondent number 1 had refused to accept the notice. So we have also already served the notice by way of newspaper in diary. So if since the respondent refused to accept the notice, if your Lordship and this humble court may allow to serve the...
Show us the provision. What is the provision of law if a notice is refused to be accepted?
My apologies, Your Honor.
You are young lawyers, you should know, you should have that inquisitiveness. What is that provision? How would I make the submission that it should be accepted? Where is your CPC?
In the chamber.
Not expected. We'll have this matter tomorrow.
Your Lordship, my senior is out of station. but
For
no,
this, you don't need the senior. You just need to point out the provision of law.
Okay.
Come prepared tomorrow.
Okay.
But tomorrow you have to show the provision.
Okay.
It's in the CPC. We have given you a clue. It's not very difficult. And so far as paper publication is concerned, that was for the IA. for the delay condemnation. That's over. Now we are in the main appeal. Appeal
Yeah,
has been
sir,
admitted.
we have served the notice.
No, notice
However,
has been issued, but there is a refusal. If there is a refusal, what is the provision which you can take benefit of? Okay? Tomorrow.
obliged.
On the prayer made on behalf of the appellant, matter is adjourned to be listed tomorrow.
Item number 6.
Tomorrow we have single bench. Yes,
My lord, this application is for condemnation of delay.
first time it's being listed. Listed for the first time.
Yes, yes.
Okay,
No-
we'll issue notice here.
Yes, my lord.
For pursuant to learned. Okay, have you seen the office note?
Not yet, my lord.
Please see the office note. Or something. You have a fan here. Put the fan. Speak to it. कमा दीजिए यानी कि उस पे ठीक है अभी ठीक What is the note? Note on the back side of the office note, yes. Second page, I think, on the.
Yes.
Yes, yes, that one.
Yes.
What is the note?
This application is a prayer for condemnation of 723 days in filing the connected appeal, which is registered as RFA 39 of 2024. On recalculation, it seems the counsel for the applicant has simply counted the days between the impugned order dated 10/11/2022 and the date of filing this appeal. The actual number of delays is found to be 632 days. Counsel for the applicant undertakes to serve copy of the application
Okay, that
to
is
the
okay.
rest.
Are you agreeing with this office note?
Yes, I am agree with my.
Why?
I accept my mistake.
Why is there a mistake on you? Is it necessary that office note is always correct? How do you calculate the delay? Where is the Limitation Act? Limitation Act. Limitation Act. Which section? You come to section 12.
Yes, section 12. Exclusion of time in legal
Yes.
proceedings.
Read the explanation part.
In computing the period of limitation of any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded.
Yes. Then read the entire.
In computing the period of limitation for an appeal or an application for leave to appeal for revision or review of
No,
judgment.
explanation.
Yes. In computing under this section, the time requisite for obtaining a copy of a decree or an order, any time taken by the court to prepare the decree or order before an application for a copy thereof is made, shall not be
Shall
excluded.
not be excluded.
Yes.
What is the date of the impugned order? In
Uh,
your case?
10/11/2022.
10/11. When did you apply for certified copy?
Yes, I have.
You applied on 25/9/2024.
Yes.
By the time limitation is already over.
Yes.
So you will not get the time. Office note is not correct.
Yes, my lord.
Please inform. it would be applicable when you apply during the limitation, when the limitation is still there.
Yes.
If the limitation is over, there is no further, you will not get any benefit. Your calculation is correct.
Yes, my lord.
Okay. Third precedence, learned counsel, for the applicant who by means of this application has prayed for condonation of delay of how many days?
723 days.
723 days. Full stop. Office note is given back. Given back the office note. Okay, okay. Para. Let notice be issued. Returnable by 6 weeks. Let steps be taken for service of notice upon the sole respondent by registered post with AD. Steps within 2 days.
Obliged, my lord.
Hearing list, item number 4.
Item 4. RFA. State. Yes.
My lord, in the present matter, the appellant is the state. But it seems the case was taken up by Mrs. Mary. So she is absent today due to the sickness of her child, her baby, it seems.
We'll have it some other day.
My lord.
And when you have it on day after tomorrow?
Day after, my lord.
Wednesday, single bench is there? No. Then Friday? We can have it on Thursday.
My lord.
You come back to us regarding her status.
My lord.
If she is okay, then we'll have the matter.
My lord.
Madam, you are for the other side.
No, my lord, actually I'm representing their counsel for the state. And my lord, if it's possible that the matter be fixed on next week, since they are hospitalized and we are not sure that they will be released on this week.
Okay. Is it? Okay, Monday next then.
Yes, my lord.
Okay, Monday.
Well.
But 19 matter. Try to have them. Huh? If they're okay, we'll try to have this matter, all matters. Okay.
Obliged.
A joint prayer has been made by the learned counsel by submitting that the concerned counsel conducting the matters have some medical issues. Para? Considering the above, please this matter for hearing on Monday, 9th.
Obliged.
Item number 11.
Item 11.
Rajab, the counsel for the appellant was just here.
What is this matter?
It's a matter regarding dispute between husband and wife who have separated property. This matter can come up on Monday then, Your Worship.
I think counsel has come.
My lord, my senior is on leg and I am praying on behalf of my senior.
Okay, we have some 2-3 matters. If she comes, we'll have it today. Otherwise, we'll fix it.
Okay.
Item number 12.
My lord,
RFA. Yes, what is
this
it?
is the first appeal, my lord. And the appeal is against the impugn order passed by the trial court. The Court of Civil Just Senior Division in connection with Civil Suit number 97 of 2012. 2012, judgment and order dated 14/12/2021. Here, my lord.
Who is for the other side? State counsel. Who has been entrusted with this matter?
Yes, my lord, the concerned counsel is on lag.
He is not present.
She is on another court, my lord.
Okay, wait for a while.
My
Let her
lord.
come.
My lord.
Item number 13.
Okay, okay, well, then we'll have this. Well, this will be cut after some time. Same council. Okay.
Item number 15.
So what about 14? 14 was regulated. Amicus
Item 14.
14. Okay. You had to wait for some time.
Please, Your Lordship.
What was-
Lordship, I have taken the consent of the.
Okay. Now matter has been called. Now even consent is not required. If you make a mention in the morning, you have to take the consent. Don't. What is your prayer?
Lordship, if
Your
this-
senior is not.
Yeah, my senior has taken leave until 13th.
We have already written the order. No? Okay. When do you want the matter to be listed?
Lordship, if this matter may be taken up any date after vacation.
List after the winter vacation.
Obligation.
Item number 15.
MSc appeal.
My lord, yes. This is MSc appeal, my lord.
Other
Against,
side present.
the other side is not present, my lord.
Why? What is your appeal?
My lord, my appeal is with regard to the impugn order passed by.
No, that is okay. Now you have come for. You are the owner or what?
No, my lord. Yeah, yes. Actually, initially the vehicle was owned by the third party, my lord. And from the third party, I purchased that particular vehicle, my lord.
And the accident had occurred before you had purchased or after you had purchased?
After purchasing, my lord. After
Then how do
purchasing the
you,
vehicle.
how do you deny the liability?
My lord, here by passing the impugn order, the lower tribunal had relied upon the alleged purchase sale letter, the purchase sale letter, and as the insurance certificate was not valid at the time of accident, so all the liability to pay compensation of that compensated amount was.
What is
to be-
wrong? What is wrong with that order?
My lord, here the main grounds of appeal in connection with this make appeal is with regard to the mode of computation of income, my lord.
Okay.
The mode of compensation.
How much has been granted?
The total amount granted was rupees 39 lakhs 25,800, my lord.
It's a death case.
It's a death case, my lord, yes.
What was the deceased doing?
The deceased is doing blacksmithy as per the allegation, as per the allegation, yes, evidence adduced by
He was
the
doing what?
blacksmith.
Blacksmith.
Blacksmith, yes.
What was his monthly income?
The monthly income is written as 29,000, madam.
What was the documentary evidence?
The commentary evidence here enclosed by the complainant is with regard to the acknowledgement of the concerned local council president, madam.
He had said that he used to earn around 29,000 per month.
Yes, that only that much.
That has been relied upon.
Yes.
And
By
how are you disputing that? What grounds?
My lord, my grounds is that by simply saying the local council chairman of that area simply said that the monthly income is 29,000 only. But in this...
That chairman was subjected to cross-examination. Did you cross-examine him?
No, my lord.
If you have not cross-examined, then how do you challenge if it is reliable or appears to be a reliable piece of evidence? If it is something absurd that he was earning some 2 crores per month, then matter. He's earning 29,000. It's not very on the higher side, and you have not cross-examined.
My lord, here,
You may be right. The statement may not be based on facts, but you need to put a cross-examination, put a question that what is the basis of your statement of 29,000. You have not done that. Do
Yes.
you know the counsel for the other side?
yes, I know, my lord.
Please inform them. We'll have this matter tomorrow or maybe.
But my lord, in this respect, we cannot serve service of notice to the claimant. Even when we publish the service of summons to the local newspaper, then they did not respond.
Doesn't matter whose names are there now on the other side.
The only name available is the
Insurance company.
No, my lord.
Then
OP number 1.
who is OP number 1?
OP number 1 is
Your earlier purchase, your
I'm for
vendor.
the appellant. I'm for the appellant, and OP number 1 is Srimati Vanal Moni, my lord.
Who is she? Your vendor. From from whom you have purchased the vehicle.
Sorry, Srimati Lalchan Hemi. Sorry.
Who is she?
She is the owner of the vehicle.
And who are you?
I am also the owner of the vehicle.
You are the subsequent owner. She is the vendor from whom you have purchased the vehicle, isn't it? She is there. She is not the contesting party. If the claimant has chosen not to contest, we will go ahead. That's not a issue.
My lord.
And who are the other respondents? Who is the R2? Respondent number 2?
Respondent number 2 is the. Here, respondent number 1 is the owner, the claimant, my lord.
One has not appeared.
One is represented, not represented, and 2 is represented by the council, but they did not appear today, my lord.
One has not appeared.
Yes, my lord.
Now, what is the status? Is there any stay order?
There was no stay order as of now.
The award is of which year? Award is of which year?
Award is, my lord, as per the judgment and order 2024, February, 2nd February, my lord.
They have not gone for execution of the award.
No, my lord, they did not go for an execution.
Where is your newspaper publication? Have you filed yet? Filed in the
It
court?
may be available in the file, I hope, my lord. That steps was taken for service of notice.
Newspaper?
My lord.
If there's any newspaper. Which date? Okay. This was published when? August.
The last local newspaper publication is
Yes,
on,
we have seen that.
my lord.
There is a small problem here. See, on the first date, this court had issued notice
My lord,
The
my lord.
appeal was not admitted as such. 2/5/2024 notice was issued,
My lord.
pursuant to which you had taken steps. It could not be served, so you had prayed for a paper publication.
Yes, my lord. Yes.
Which you have already accordingly done. Thereafter, when the matter had come up on 9/9/2024,
My lord.
the appeal was admitted and you were asked to take again steps upon the both the respondents. Two had already appeared, so not an issue.
Yes, yes, my lord.
One, you have to take steps by registered post with AD. Did you take steps? You take steps. This was actually not necessary. I do not know why. Okay, one, just a minute. In view of the notice, duly served. Okay, not required. There's a subsequent order of 2910.
My lord.
Rightly done. What do? If you want to proceed, we can. But
My lord, if time may be given to inform the council for the respondent number 2, and if the matter can be fixed within this week, my lord.
Okay, Friday.
To this post of the matter, my
Friday.
lord.
Friday.
My lord.
Though the learned counsel for the appellant is present, none is present for the respondents. Full stop. This court has noticed that the respondent number 2 has appeared through counsel, whose names also appear in the cause list. Full stop. So far as the respondent number 1 is concerned, the previous orders of this court, including the order dated 29/10/2024, had clarified that since the said respondent was served through newspaper publication, the service was held to be complete. Para, be that as it may, in the interest of justice, the matter is adjourned to be listed on Friday. Okay, 6th. Okay? 6th.
My lord.
For hearing.
My lord. Obliged.
Earlier matters. Okay, they have come. Item number?
My lord, regarding item number 11, can this matter be listed tomorrow? Because
Okay. Here for the appellant.
yes,
Okay. Yes, respondent state, not state. Other side respondent, we'll have it tomorrow?
yes, my lord.
Okay. On a request made on behalf of the appellant, learned counsel for the appellant, matter is adjourned to be listed tomorrow.
And my lord, regarding item number 13, can
Yes.
the matter be listed next week?
13, next Monday.
Obliged.
Item number 12.
12 we had just had, one. What was the other one? No, what was the other one? No, just now 2 matters. Vinay, number 11 and 13, okay.
Lordship, I'm appearing in this matter. I'm appearing for the state respondent.
Yes.
That is respondent number 7 to
Yes.
21, 1 to 6. Lordship, necessary party herein, the private respondents are not are absent today. They are not here. So if this matter can be,
They have entered appearance otherwise.
yes,
Council's name are shown.
yes. The private respondents are here. So if this matter can be taken up some other day, not today, Lordship.
Can you inform the
Yes,
council?
I'll inform them.
Oh, we'll have it on Friday or try it on Friday?
My lord.
Though the learned counsel for the appellants as well as the learned state counsel are present, the learned counsel for the private respondent numbers 1 to private respondents are
Yes, 7
not-
to 21.
7 to 21 are not present in spite of names being reflected in the cause list para. In the interest of justice, matter is adjourned to be listed on Friday for hearing. Oh, no, this will remain, I think. Friday? This is for 1 week, isn't it? This order, madam. Orders have been passed. Okay, let the order be there.